All right, Pete. Well, thank you so much for the opportunity to be here and visit with you guys today about Texas water law. I am an extension ag law specialist with Texas A&M AgriLife Extension. I'm stationed in our Amarillo district office, and I have to say that water law is definitely one of the top questions I get, both from folks who are calling me on the phone and at presentations where I speak. So absolutely, this is a hot topic in Texas, and I'm excited for so many of you guys to be on the webinar today. I have to give a little disclaimer before any presentation I do. I blame it on law school for ruining me and making me do this. But so today I'm going to give you some educational information. I can give you some general information about generally how the law works, some things to think about, some questions you might want to run by your own attorney. What I can't do is give anybody any specific legal advice. And that makes sense because I'm not your attorney. If you need an attorney, you're going to have to go find somebody who bills you by the hour. And I'm here for free. So no specific legal advice today, but hopefully we're going to give you some general information that'll be useful. Here's kind of the roadmap of what we're going to cover today. We're going to start off with defining the categories of water when it comes to Texas water law. And the applicable law actually depends on the category of water that we're discussing. So we'll start there. And then we're going to look at groundwater. We're going to talk about the basic law. And then we're going to kind of talk about two hot topics. One of them is the Bragg versus Edwards Aquifer Authority case. And the second is some water pipeline projects. The odds are you guys may have heard about both of these in the news. They're pretty current, pretty important. So we're going to talk through those issues today. When we're done with groundwater, we're going to turn to surface water. And again, we'll talk through the basic law. And then we're going to talk through an important case in Texas specifically for agriculture, the Texas Farm Bureau versus the TCEQ. That's my plan today. Kind of as we go along a couple times, I will stop. If you guys have any questions as we go, if you'll feel free to type them here in the chat box. I'll take a couple of short breaks as we go and try to answer any of those questions as we go along. If you'd rather not ask during the webinar, that's fine as well. At the end, I'll be providing you with my contact information, phone number, and email. So if you'd rather ask any questions that way, that's perfectly fine as well. So we'll get started. Like I said, the type of law that applies in Texas depends on the category of water that we're talking about. So we split water into two main categories, groundwater and surface water, and then there's actually subcategories within each of those. With groundwater, the subcategories are percolating groundwater. That's groundwater in an aquifer, so beneath the ground, water in an aquifer. The second category is a subterranean river. None of those have ever been found in Texas, and so when we talk about groundwater today, we aren't even going to worry about subterranean rivers. We're only going to be talking about that percolating water found in an aquifer. Like I said, our second major category of water is surface water, and again, we break that into two subcategories. We have surface water in a defined watercourse. That's things like streams, rivers, lakes, the Gulf of Mexico. And then we have diffused surface water. And what that is basically storm runoff, rainwater, prior to reaching a watercourse. And when we get to the surface water portion of our discussion today, we'll talk through the difference. What is a defined watercourse? How do you tell these waters apart? And why does it matter? So let's start with groundwater. I pulled a little bit of data on groundwater use. Texas uses about 10.2 million acre feet of groundwater every year. Just so everyone's on the same page and we all understand what an acre foot of water is, it's a pretty common measurement when we're talking water. It's the amount of water needed to cover 1 acre of land 1 foot deep. And so an acre of land is roughly like 75 yards on a football field. So if you imagine the amount of water we need to cover 75 yards on a football field, 1 foot deep, that's an acre foot of water. 80% of groundwater is used by agriculture. mostly for irrigation. About 15% of Texas groundwater is used by municipalities. So the basics of groundwater law. The key question we have here, who owns the groundwater in Texas? So think for a minute. It always is interesting to me. Some people, when I'm at presentations, absolutely don't know the answer to this question. It's an important one, particularly for landowners, because under Texas law, landowners own the water beneath their property. Both state statutes and the Texas Supreme Court have made clear that landowners have a property right in the groundwater beneath their land. Groundwater in Texas is governed by what we call the rule of capture. And what that means is essentially the landowner has the right to pump as much water as he can or he wants, even if that harms his neighbor. Now, you see my little note here. This is subject to a couple of limitations on the next slide, so bear with me. This is going to be important. But the general way the rule of capture works, the idea is everybody has the right to capture water regardless of how that impacts their neighbor. And this came about in the East case, which happened back in 1904. And in that case, Mr. East owned some land and he had a water well on his land. The railroad company moved in next door and they drilled a well on their property. Their well was bigger and deeper, and so we all probably can guess what happened to Mr. East's well. It went dry. And so Mr. East filed a lawsuit in court, and his theory was, I had a groundwater well, they moved in next door, they sucked my well dry, I'm entitled to damages. Seems like a pretty good legal argument. The Texas Supreme Court said that's not the law in Texas. Mr. East does not have a remedy at law against his neighbor because of the rule of capture. Instead, Mr. East has a remedy in the real world in that he can go and drill a bigger, deeper well himself. And because of that, a lot of people, particularly outside of Texas, refer to Texas groundwater law as the law of the biggest pump. So if we fast forward almost 100 years to the Day case, this was a Texas Supreme Court decision in 2012 dealing with groundwater. And the question there was, does a landowner have a property right in the water in place beneath his land? Everybody pretty much agreed that a landowner had rights to the water once he captured it and pumped it up through the well. But Day actually said that the landowner has a property interest in that water in place beneath his land even before it's been pumped. And in just a minute, we'll see why that's important when we talk about the Bragg case. So like I said, we have the general rule of capture, but it's subject to some pretty important exceptions. Ownership of groundwater does not give the landowner a right to capture a specific amount of water or to waste water. And there's sort of two categories of exceptions to the rule of capture. One of them is what are kind of categorized as common law exceptions. These were developed in the case law, in judge-made law, when judges make decisions. These were developed. Some of them have now been codified. I like to think of these as the don't be a jerk set of rules. So it's things like you cannot maliciously take water if your sole purpose is to injure your neighbor. So let's say, back to our example of the East case, if the only reason the railroad company drilled that well was in order to make Mr. East's well go dry, that would not be allowed. You do not have the right to intentionally waste water. You can't drill or pump in a way that causes subsidence, which is where when you pump the water out, the surface of the land sort of collapses. You don't have the right to pump from a contaminated well, and you can't trespass on another's property in order to drill. So like I say, these are sort of, I don't know if common sense is the word, I think of them as you can't be a jerk with regard to water. The other major exception to the rule of capture that applies in some portions of Texas are groundwater conservation districts. What these are, it's the state's preferred method of groundwater management. And so here's how this works. Under the Texas Constitution, the legislature was given the authority to manage natural resources in Texas. That includes groundwater. And what the legislature decided was, instead of managing this on the statewide level, like instead of having something like a Texas groundwater board, they decided it would be better to have local groundwater conservation districts out in different areas that manage the water on a local level. And one main reason for this is the diversity of the land in Texas. The way we manage groundwater in Amarillo may be very different from how it should be managed in Houston, which may be very different from how it should be managed in El Paso. And so the idea was that these local districts would be in a better position to manage groundwater. And so currently in Texas, there are 98 groundwater conservation districts and 4 that are pending confirmation by the voters. They cover all or part of 174 counties, and they govern about 85% of the groundwater in Texas. I'm going to show you a map here in just a minute that'll show you kind of where these districts are. They do several different things. They develop strategic plans to promote efficient use, to prevent waste, to promote conservation of groundwater. So they have a planning function that's important. They also have a permitting function that we're going to talk about in just a second. So here's a map of the groundwater conservation districts in Texas. So you see here we've got the 98 districts, all in different colors. So anywhere that's white, you see some of these white areas, those are areas that are not governed by a groundwater conservation district. So what that means in those areas is that the only rules that apply there are those common law exceptions that we talked about. If, however, you're located in an area with a groundwater conservation district, then the rules of that district apply. And so it's really important to know, A, whether you're in a groundwater conservation district, and then B, to understand the rules of that district. One thing, let me point out a couple of things here. So if we look over here at Culberson County, which is out towards El Paso, you see district number 21. You can look next door in Hudspeth County, you see district number 39. Those districts only cover part of the county. So it's not necessarily an entire county covered by a district. It can be just a portion. We also can see examples of multi-county districts where you've got several counties here in one district. We can have single county districts where a district only governs one county. What makes this all very tricky is that each district has their own rules. And so I've talked to a couple of landowners who own a ranch that maybe crosses district lines. And on one part of the ranch, one district's rule applies. On the other part of the ranch, the other district's rule applies. And they've got to follow different rules depending on where they are on their property. So that can make for a pretty complicated situation. Groundwater districts have 3 main powers. The first is to create rules. The second is to plan, like we mentioned earlier. And then the third is to permit the use of groundwater. So by state law, a groundwater conservation district must require a permit if a well is going to be drilled or operated, or if the pump size of a well or pump is going to be altered. And so if you're in a groundwater conservation district area and you want to drill a well, the general rule is you have to go get a permit from the groundwater conservation district to do that. Groundwater conservation districts by state law also must require that driller's logs be kept and filed when a well is drilled. They may require records and reports of drilling and production. We see some districts that require landowners or well owners to file a production report periodically. Sometimes it's once a quarter, sometimes it's once a year. Some districts have developed those rules. Districts may regulate spacing of wells and production of groundwater. So there's some districts that have rules that you can't drill a well within 200 feet of another well, or you can't drill a well within 200 feet of the property line. And the reason for these spacing requirements is that we're trying to avoid the situation with Mr. East, where the neighbor came in and puts a well next to the property line and drains the other neighbor's well. Some districts regulate production of groundwater, and so there are districts in Texas that say things like, you can drill a well, but you can't pump more than whatever the amount is, 2 acre-feet a year, or so many gallons a day. And then districts may impose export fees for groundwater that's going to be taken out of the district and used elsewhere. Like I say, it's really important that you understand the rules of your specific district because every district is different. And you've got to make sure you're abiding by the rules that are applicable in your area. Most of the groundwater conservation district rules are available online. If you've got any trouble finding the rules for your area, if you'll contact me, I'm happy to help you find those and get you a copy in your hands. Now, we just talked about how if you're in a groundwater conservation district, the general rule is you've got to get a permit before you can drill a well. Well, of course, because this is legal issues and lawyers like exceptions, there are some exceptions to these rules. So there are certain types of wells that no permit is necessary for. And this is actually a state statute, so this applies in every district, every groundwater conservation district. So the first exception is if you want to drill a domestic well or a well for watering livestock or poultry, and you're located on 10 acres or more, and your pump is not capable of producing more than 25,000 gallons a day, then you're exempt from the permitting process and you don't have to get a permit from the district before you can drill your well. All right? The second exception deals with rig supply wells for oil and gas operations. If it's water used for a rig that is actively engaged in drilling or exploration operations, then those wells are exempt from the permitting process as well. There's an exception for water use for mining activities. So those are the three statewide exceptions by state statutes. Now it can be tricky here again. These exceptions, like I say, are statewide. They're a baseline. They're the lowest exceptions that there can be. A groundwater district can actually allow more exceptions. They could make this broader. So for example, a district could say that any domestic or livestock well is exempt regardless of the size of the land or the size of the pump. There are some districts that say any agricultural well is exempt, and they define that much more broadly than just a livestock well. So again, an example of why it's so important to make sure you understand the rules of the district where you reside. Okay, if we have any questions on groundwater, general laws, go ahead and type those in now. We're going to talk about the Bragg case next, and then I will come back and talk about answer any questions that we can answer quickly during the presentation. All right, so Bragg versus Edwards Aquifer Authority. This case has been in the news quite a bit. It's a pretty interesting case that I think could have pretty important impacts on water law in Texas. And so the Bragg case came about down in Medina County, which is sort of around San Antonio. And the situation is this. There's a pecan farmer who owns land, and he's got 2 pecan orchards down in Medina County. One orchard, I should back up. He bought the land back in the 70s and 80s, and he planted his orchards. At that time, there was no entity that governed groundwater use in that area. Since then, the Edwards Aquifer Authority has been created. And now one little note on the Edwards Aquifer Authority. The EAA is not a groundwater conservation district. It was created by separate legislation. 2 different bills created the Edwards Aquifer Authority and groundwater districts. So they're not the same. For our purposes, they are similar in that they both manage groundwater use. The Edwards Aquifer Authority obviously manages that out of any water in the Edwards Aquifer. So they're similar. They're not exactly the same. This distinction could make a difference going forward for groundwater districts. We just don't know yet for sure. All right, so Mr. Bragg owns this land. He's got 2 pecan orchards. The first orchard he had always watered since the 1970s with Edwards water. The second orchard he had never irrigated with Edwards water. He'd used a different type of water for that. So we've got this situation, and Mr. Bragg has been watering his trees for years. Well, the Edwards Aquifer Authority was created in 1996 to manage groundwater in the Edwards Aquifer. And as part of its creation, it required everybody who wanted to irrigate out of the Edwards to come obtain a permit from the EAA. And in order to get a permit, what you had to show is that you had historic use of Edwards water. And so Mr. Bragg went in and he filed his permit application with the EAA. So for the one orchard that he'd always watered with Edwards water, he could show historic use, but he actually asked for about double the amount of water he historically used. And my understanding is his explanation was his trees were bigger now and they took more water now than they did during the historic period from like 1980 to 1993, I believe. For the other orchard, he could not show any prior use, but he applied for a permit anyway. And the Edwards Aquifer Authority denied his permits. For the one orchard, they actually granted him half the water he requested. That's the one he had irrigated with Edwards water before. So basically what they did is they gave him the amount of water he had historically used. But on the second orchard, they denied his permits. And they said, you cannot irrigate with Edwards water at all on that orchard. And so Mr. Bragg filed a lawsuit. And here was his legal theory. Remember earlier when we talked about the Day case and how the Texas Supreme Court said that a landowner had a property right in the water beneath his land? Well, Mr. Bragg took this a step further, and what he said was, if I have a property right in the groundwater beneath my land, and the Edwards Aquifer Authority, acting as a state entity, is telling me I cannot use that property right, that constitutes a taking of my private property, and the Constitution says I must be compensated for a taking. So it's a pretty interesting legal theory. And Mr. Bragg filed his lawsuit against the Edwards Aquifer Authority, claiming that their denial of his permits were a taking and that he deserved just compensation. The lower court sided with Mr. Bragg. Both the trial court and the Court of Appeals said that the denial of his permits constituted a taking and that he was entitled to just compensation. Now, there was some difference in the two courts about how compensation should be calculated, but the important part was that they both found there to be a taking. So here were the arguments of the parties. Like I say, Mr. Bragg said that the denials constituted a taking. The Edwards Aquifer Authority said, no, it's not a taking. We've got the right to regulate groundwater. The law that was applied to this is called the Penn Central Balancing Test. This came out of a case in the United States Supreme Court, the Penn Central case, and it's sort of a 3-part test that courts use when they're trying to decide if a regulation constituted a taking. And so the first thing courts look at is, what were the investment-backed expectations of a landowner? And the court here looked at this and said, well, when Mr. Bragg purchased his property back in the 70s and 80s, he expected to be able to plant his trees and irrigate them. There was no entities governing groundwater at that time. His investment-backed expectations were that he could invest money in these orchards and recover that because he could irrigate with the water. The second thing they look at is the economic impact on the landowner. And here it was a major economic impact, looking at what would happen to Mr. Bragg's trees if he was unable to irrigate. So that weighed in his favor as well. And then the courts look at the character or the importance of the government action. And so here what they look at is how important is it that we have a government entity be able to manage and regulate groundwater use. And the court said that's a pretty important thing for us to be able to do. We understand this is necessary, so that weighed in favor of the Edwards Aquifer Authority. And basically what the court does is it balances these three factors and comes to its conclusion. And like I say, the lower courts found for Mr. Bragg. The Edwards Aquifer Authority appealed this case to the Texas Supreme Court, and here just in the last month or so, the Texas Supreme Court said that it would not hear the appeal. So this case will not be appealed. The decision of the Court of Appeals is final. That decision is that a taking did occur. The case will be remanded to the trial court for the court to properly determine the amount of compensation due to Mr. Bragg. So why does this case matter? I always like to kind of get on a practical level. Why do we care about this case? Well, it's the first application of the day principle that we have an ownership interest in the water beneath our property. And if you've got a property right, then if the government takes that property right, you're entitled to compensation. So this case tells us that at least under these facts, a taking did occur and compensation is going to be owed. Now, importantly, is every time a groundwater district or the Edwards Aquifer Authority denies a permit going to constitute a taking? I sure don't think so. I hate to ever predict what a court's going to do, but the kicker here is we've got to do this Penn Central balancing test each time. And when we do that test, just a few facts being different could really change the outcome. For example, if Mr. Bragg had purchased his property in 2012 instead of 1980, and at that time there had already been a groundwater district in place, and he knew he had to get a permit before he ever planted his trees, the analysis might be very different. So I certainly don't think that this case is something that's going to make every time a permit is denied constitute a taking, but it does indicate that there are certain situations where takings can occur, and that's pretty important. The last point I want to touch on with groundwater deals with the proposed pipeline projects. You guys have probably heard about these in the news. They're popping up kind of several different places in Texas. As an example, I want to use the San Antonio Water Systems pipeline project. So what happens here is San Antonio needs water for its growing population, and it's been looking for years at different options to get additional water. It looked at things like desalination. It looked at aquifer storage and recovery. It looked at all different options, and it decided that it was interested in a pipeline project. And so it created an RFP, a request for proposals, for a pipeline project. And the idea was that it would take proposals from a company that could go out, get groundwater somewhere else, and pump it to San Antonio. And so a company called Abengoa went out to rural Burleson County and leased up a bunch of water rights. So Burleson County, for those of you who don't know, is right by College Station. Caldwell is in Burleson County. And so Abengoa went out and it leased water rights from, I think it was something like 3,500 or 350? Anyway, from a bunch of different landowners, it leased water rights. And then it went to the Groundwater Conservation District. And it got approval, got a permit like it was required to do, to pump 50,000 acre-feet a year from Burleson County and the Carrizo-Wilcox Aquifer to San Antonio to sell to the city. And so San Antonio Water Systems and Abengoa negotiated a contract to make this project happen. It's a $3.4 billion contract that's going to last for 30 years. Like I say, the contract is for 50,000 acre-feet a year. The estimated cost of delivered water is going to be $2,300 an acre-foot. And this is enough water to serve about 162,000 families in San Antonio. And here's a map just to kind of show you where things are located. So the green square is where the water well field will be. That's where they've leased the rights. The red here is a proposed where they would have the pipeline go, and then it would pump to San Antonio. All right, so that's sort of what we're looking at as far as the map goes. So why do we care about this pipeline project or any pipeline projects? Well, there's a lot of people who care and have a lot of different opinions. So let's talk through some of these. Those landowners out in Burleson County who signed groundwater leases want their money, right? And their thought process probably is, I have a property interest in this water beneath my land. I have the right to lease it. I have the right to make an income. I think some of these leases involve royalties, kind of like oil and gas. I have a right to collect that royalty on my water. And so, I've got the right to do this. The groundwater district approved it. We want our money, right? But landowners who didn't sign leases want their water to stay put in Burleson County. So imagine if you're a landowner who did not sign a lease and you said, I'm not signing your lease. I'm worried we're going to run out of water. I've got to irrigate my corn. I'm not signing. Well, you're pretty upset right now because if your neighbors all signed leases, does that water care who signed the lease and who doesn't? No, right? When they pump that water, it very well may drain your well, even though you didn't sign a lease. So we've got that popping up as an issue. We've got nearby groundwater conservation districts that want their water to stay put. One example of that, there's a district right nearby who a similar pipeline project came up in their district about a year or so ago, and they actually denied the permit. They said, we don't think there's enough water in this aquifer to allow this amount of pumping. That district's not very happy with the district in Burleson County who just approved the pumping because, again, they're all pumping out of the same aquifer. San Antonio residents need water, but there's some of them that are not very happy about the cost increase. So that's another issue that some people are dealing with. There are landowners along the pipeline project who are not very happy about the potential use of eminent domain for the project. That would be the government, or not the government, I'm sorry, Abengoa coming in and being able to use eminent domain to condemn the land in order to build the pipeline. So we've got lots of issues and lots of people who are not super happy about these projects. We've got lots of people who are happy about them. So it's an interesting issue. And I think something else these projects do, and again, it's not just San Antonio. We've got a similar issue. There's a project that's looking to pump some water into Buda, which is right outside of Austin. I think it really highlights the issue of rural versus urban water in Texas. And it's something that those of us involved in agriculture certainly need to be aware of and paying attention to. All right, so as far as questions on groundwater rights go, it looks like one of the questions here deals with surface water, so I'm going to just hang on to that one. House Bill 2647, I have to admit to you I don't know a lot about that. I pulled it up while we were talking. It looks like it was vetoed by the governor. So that bill did pass, but it was vetoed by the governor, so it did not become law. So hopefully that's at least some sort of information. Steve asked if the written presentation would be available online. Steve, if it's not available online, you can certainly email me, and I am happy to send you a PDF of the presentation. And then Mike, who is probably who should be teaching this presentation and not me, Mike put a link of some interesting language about groundwater rights and the importance of groundwater management in one of the governor's veto proclamations. And that deals with House Bill 2647. So Kathy, there's some info from Mike that would be useful. Wendy asks, on the Abengoa project, if there is a drought, do the rights trump the non-signing lease residents of the region? That is a good question and something that we're going to have to see how that'll play out. If there's a drought, the odds are the groundwater district in that area is going to wind up finding themselves in court. Because if they curtail water rights, there may be a problem. If they allow the water rights to go on and the people who didn't sign run out of water, there could be a lawsuit. So that could be an interesting question that I hope we don't have an answer to, but I fear we may. I will definitely be happy to give you guys my email address and my phone number at the end of the presentation, so hang tight for that, Steve. Okay, let's move on to surface water. When we're dealing with surface water, Texas uses about 6.6 million acre feet per year of surface water. That's less than the 10.2 million of groundwater that we use. Most of the water here is used for cities and industry, about 65%. 35% is used for agricultural irrigation. And so when we talk about surface water basics, remember at the beginning we said that there are two basic types of surface water. Surface water in a defined water course, which I'm going to refer to as regular surface water, and surface water, diffused surface water, which is basically storm runoff before it gets to a defined water course. So it's important that we know what is a defined water course, because that's the distinction between regular surface water and diffused surface water. Well, courts in Texas have given us a three-part test. A defined water course exists if we have a defined bed and bank, a current of water, and a permanent source and supply. The problem is this definition has been construed pretty broadly by the courts, much more broadly than most people would probably think of this as. So there have been court opinions that say things like, a defined bed and banks, we have to have that, but it doesn't have to be descript. You don't have to actually be able to see the bed and banks. We hear things like, it's got to have a permanent source of water, but it's okay if that source is just when it rains 5 or 6 times a year. So basically, the definition of a defined water course is very broad. Okay, so who owns the surface water? If we're dealing with regular surface water in a defined water course, it is owned by the state of Texas, and it's held in trust for the people of Texas to use. All right? If we're dealing with diffused surface water, then the landowner has the right to use that water while it's on his or her own property. Now, the kicker that we have here is sometimes people think maybe it's diffused surface water because it's not yet in a defined water course, but because that defined water course definition is so broad, anything in a defined water course is owned by the state. And if you want to use it, you have to get a permit from the state of Texas. All right? So if you want to use any state-owned water in a defined water course, you have to go to the TCEQ, that's the Texas Commission on Environmental Quality, and get a permit. You've got to do a permit application. You've got to show that you're going to put the water to beneficial use. And you see here a list of all sorts of things that constitute beneficial use. Domestic, municipal, agricultural. It goes on, and then at the end it says, and any other beneficial use. So it's a pretty broad definition here. Surface water is governed by what we call prior appropriation. Basically, that means first come, first serve. And so senior rights are superior to junior rights. So let's say that Pete has a water right on the Brazos River, and he got it in 1990 to irrigate his crop. Let's say I also have a water right on the Brazos River, and I got this in 2000 to irrigate my crop. As long as there's no drought, everybody gets along and we all use our water, right? And everybody's happy. But if a drought hits or there's some other shortage of water for any reason, now we've got a problem. And the way prior appropriation works is a senior water rights holder is going to get all of the water to which he or she is entitled before the junior water rights holder gets any. So in that situation, Pete would get his entire allotment of water because he got his right in 1990 before I would get any of my water because my 2000 right is a junior right. So that's how that plays out. There are a couple of emergency exceptions to this that exist. If it's necessary to protect public health, safety, and welfare, we are going to talk about those in just a minute when we get to our case dealing with surface water. So in order to use that state-owned water, a person has to apply for a water right with the TCEQ, and the right can only be granted under certain circumstances. Here's the factors that the TCEQ looks at. Is there any unappropriated water available? If all the water in a water course has been appropriated, then the TCEQ can't issue any more permits. Does the applicant seek to put the water to beneficial use? Would the use impair existing water rights? Is the use consistent with the state and regional water plan? Would the use be detrimental to the public welfare? And will the user use reasonable diligence to avoid waste and achieve conservation? Okay, so that's what we've got there. I'm going to answer a couple questions just real quick. Kathy said this defined watercourse definition that we're talking about is completely different than the EPA regulation that's going on. Kathy, I assume you're referring to the whole waters of the United States definition. Completely different issue than what we're talking about here. Steve asked the question, even if the junior right is upstream of the senior right, as far as location goes, it doesn't matter if we're dealing with junior rights or senior rights. As far as location goes, they just look at that date. So it can be a junior right upstream or a junior right downstream. They look at the priority date. Okay, so just like with groundwater, we had those exempt wells. Remember those wells that you can drill without getting a permit? We've got similar exempt diversions for surface water. And so if you want to divert water on a non-navigable stream, we're going to define that in a minute. Hang on there, okay? You don't have to get a permit for these types of diversions. If you want to build a tank or a reservoir for livestock or domestic use, you can do that on a non-navigable stream so long as it does not exceed 200 acre-foot in capacity and is for a non-commercial purpose, all right? So if you want to build a stock tank on a non-navigable stream, you can do that so long as it's not more than 200 acre-feet in capacity. You can have a commercial or non-commercial wildlife management pond, including fishing, but not for fish farming, okay? You can build that, again, if the tank or reservoir does not exceed 200 acre-feet in capacity. All right? We've got surface coal mining operations. There is an exception for that I frankly don't deal with very much. And there's an exception if you're drilling and producing petroleum down in the Gulf and the bays and arms of the Gulf of Mexico. All right? So next we need to address this issue of navigable streams. And again, we're talking here about Texas water law. We are not talking about the new definition of waters of the United States by the EPA, completely different issue. Okay? The classification of whether a stream is navigable or not actually matters for two different reasons. Okay? The first one is exempt diversions are only allowed on non-navigable streams. All right? So let me give you an example. The Brazos River is definitely a navigable stream. Everybody would agree to that. So you can't have an exempt livestock well on the exempt livestock diversion on the Brazos River. All right? But if you had a creek running through your land that did not classify as navigable, then you could have that exempt diversion. All right, so that's one reason we need to know. The second question, or the second issue that we need to be aware of is that the bed and banks of navigable streams are owned by the state of Texas. And so, here's what that means. The public has the right to use the stream even if it's flowing across private land and the landowner cannot fence or dam across that stream. So, let me walk you through this. People don't like this, all right? I didn't make the law, just so we're clear. I think it's a dumb law, but it is the law. So what this means is if we've got a navigable stream and it runs through your private property, the public has the right to use that stream. And so if somebody wants to come in their canoe down the stream through your private property, they have the right to do that, if it's navigable. Okay? Now, they do not have the right to trespass on your property in order to get to the stream. Okay? So if they have to cross your property to put their canoe in the water, they can't do it. But if they could put their canoe on the water, like from the highway, and then just canoe across your stream, now they've got the right to do that. Okay? So everyone should be asking themselves, what the heck is a navigable stream? We need to know. All right? So the first test is, there's two different tests that we apply in Texas. If a stream meets either of the two tests, then it can be a navigable stream. Okay? The first test is called navigable in fact. And what courts look at is, can this serve as a common highway for trade and travel? All right, so if you could float a boat down it, it is navigable in fact. All right, some cases have even said, for example, if you could float logs down it, it's a navigable in fact stream. So again, relatively broad definition we have here. Next up, we have navigable in law. And again, for a stream to be considered navigable in Texas, it only has to meet one of these two definitions, okay? So navigable in law says, does the stream bed maintain an average width of 30 feet from the mouth up? All right? So the question here, we're not looking at the water, we're looking at the stream bed. If it maintains an average width of 30 feet, no matter how wide the water is, it could even be a dry stream bed, okay? If it maintains a width of 30 feet from the mouth up, it's considered navigable. All right? So important for us to know here. The TCEQ and the General Land Office kind of make some initial determinations. I am told the General Land Office has kind of a map that shows some of these. The bottom line is the court's going to be the final say. And so because it's a factual thing, they've got to look at the facts, they've got to look at the different issues to figure this out. All right? I'm going to answer a couple questions real quick. Wendy, you just said, oh, you're asking about the gradient boundary line. So Wendy says, can't people use up to the gradient boundary line, which can vary along the water course? Yes, okay? So basically what this says is, if we've got a stream that's navigable, then the state owns the stream bed, and the way they measure that is from gradient boundary line to gradient boundary line. Right? And basically, I am no, I don't even know what the term is, but I'm not a person who studies this sort of thing. But basically, there's a spot on the stream bed where the rock kind of changes, and that's the gradient boundary line. A person who can use the stream can use it from gradient boundary line to gradient boundary line. They cannot go above the gradient boundary line onto your private property. All right, so that's where that's measured. Steve asked if they have the right to portage a navigable stream. That I actually have never looked into. My understanding is I think that they would be able to. As far as I know, portage is where you carry like the, if you carry the canoe above your head to get past somewhere where you can't use the water. As long as they're in that stream bed and they don't come up above that gradient boundary line, then I believe they would have that right. Yes. Alan asked a question, where does pumping out of a spring at ground level or slightly below fall? Alan, good question. So basically what the rule is once groundwater can switch to surface water, right? So once groundwater comes up out of a stream and is on the surface, now it's considered surface water. And so if you're pumping from above ground, it would likely be considered surface water. If it's below ground, it would likely be considered groundwater. Okay, and then Kathy asks, 30 feet from the mouth up to where? How do you decide where it starts? Kathy, this is one of the problems with this test, is it is a very subjective test. It's a case-by-case basis. Exactly where they measure and how far they go depends on the circumstances of every case, and that's what makes it so tricky. Okay, let's move on. We've got about 12 minutes left. I want to talk about a case, a surface water case, the Texas Farm Bureau versus the TCEQ. Here's the facts of the case, all right? Now, remember, we're dealing with surface water, and we've got Dow Chemical is a 1942 water holder on the Brazos River. Okay, so that means they got their water rights on the Brazos River in 1942, and they used their water in some of their plants in that area. The drought hits in 2011. In 2012, Dow Chemical does a priority call. And so what that basically means is Dow Chemical contacts the TCEQ and says, hey, TCEQ, we've got this droughts going on. There's not enough water to go around. you need to cut off all junior users that are junior to our right so that we get our allotment of water. Right? So, and that's what you do. That's how you enforce the prior appropriation doctrine. And so the TCEQ looks into it and they agree. They say, yeah, we don't have enough water to go around. And so we are going to grant the priority call. And so what they did is they sent letters to about 800 people, 800 users, water right holders on the Brazos River that were junior to 1942. And they said, you are curtailed, you can't pump now from the Brazos River, right? But they made some exceptions. They didn't cut off all junior users. They said if you're a municipality or a power generator, you can keep pumping. Interesting, right? And so what they did, like I said, is they suspended about 841 rights. Of those, about 700, and I think it was 750 or 770 are farmers who were irrigating along the Brazos. All right. They exempted 19 rights. So there were 19 municipalities and power generators that got exempted, and they got to keep pumping. And those 19 people had water rights to use 1.8 million acre feet of water a year. So the farmers argue, hey, this violates prior appropriation. They're not following first in time, first in right. And this makes sense, right? So the farmers get together with the Texas Farm Bureau and they file a lawsuit. And they say, listen, we understand that if you're a user junior to 1942, you can be cut off in a drought. We understand that. But what we think you can't do is cherry pick certain types of users that are junior and let them keep pumping. That violates prior appropriation, and so they filed a lawsuit. The TCEQ said, wait a minute, there's a statutory exception that gives us the power to do this in an emergency. And they relied on Texas Water Code Section 11053. And what this section basically says is, during a period of drought or other emergency shortage of water, the executive director can, in accordance with priority of water rights, temporarily suspend a water right holder or temporarily adjust the diversion that can be made. And so the TCEQ says, here you go, we have a drought, we have the right to temporarily suspend water rights. Well, both the lower courts, the trial court and the Court of Appeals, sided with the Texas Farm Bureau. And they said the TCEQ can suspend and alter rights under 11.053, but the orders have to comply with prior appropriation. And if we look at the statutory language again, see this part in red? So basically what it says is if there's a drought, the TCEQ may, in accordance with the priority of water rights, first in time, first in right, suspend the water. And so what the court said was, yeah, you have the right, TCEQ, to come in here and cut off junior water rights. But again, what you can't do is cherry pick out certain types of users who get to keep pumping. Okay? So like I say, the TCEQ appealed that decision. The appellate court sided with the farmers again, reached the same ruling. Just last week, the TCEQ filed a petition for review before the Texas Supreme Court. They're asking the Supreme Court to weigh in on this issue. I'll definitely be keeping an eye on that to see if the court decides to take that up. So why does this case matter? Well, if you're one of those 700 folks that were trying to irrigate your crop on the Brazos and got a letter that said, hey, we're going to cut you off, you care a lot about this case, right? For those guys, it meant whether or not they received water. Okay? What it does is it makes clear that at least under the Court of Appeals opinion, the TCEQ cannot ignore priority when it's acting under 11.053. All right, important decision that is new that we didn't know. All right, so then it also prevents an end run around another type of statute, which is 11.139. What 11.139 does is it basically says on an application from a water rights user, the TCEQ could cut off junior users in certain circumstances if it's necessary for the health, safety, and welfare to do so. But if you're going to act under 11-139 and cut off certain users, you have to actually pay just compensation to those folks whose water you're cutting off. All right? TCEQ didn't rely on this statute. And one of the arguments of the farmers was, hey, they're making an end run around this other statute that would give compensation, and they're trying to cheat and use 11-053. There are, at least back in 2012, there were similar disputes going on around the state. I know there was an issue out in San Saba where a priority call was issued, but it made an exception for domestic and livestock users. So again, just like the pipelines, it's not really a situation where it's just one place this is going on. It can go on all over the state. Quickly, I know we have some more questions. Here's what I'm going to do. I'm going to go ahead and give you my contact information now. I will answer questions until we run out of time. If you've got questions that didn't get answered, please feel free to email me or call me, and we'll see what we can do on that, okay? So one thing I want to tell you about is my blog. If you look here, I've got a blog where I blog about Texas agricultural law. I do a lot of water blogs because that's such a big issue. The website address at the top here is agrilife.org/TexasAgLaw. All right. If you go where you see this big red arrow where it says subscribe, if you enter your email address there and then follow the steps that it requires, you can sign up as a subscriber, and every time I post, it'll come directly to your inbox as an email from me. So if you're interested in that, please sign up. If you want to read any of the blogs I've done about water law, see there it says view by category, kind of a box there on the right. You could go down and click on water law and read prior posts. I did a kind of a 4-part series on Texas water law. I've got another category you could click on that deals with pipeline projects. So please feel free to use that anytime. And if you've got any issues with that, please let me know. Oh, my contact info is not here, Pete. Okay, I tell you what, there should be a slide with my contact info. I don't see it. So here's what we're going to do. I'm going to give you my phone number. All right, it is 806-677-5668. All right, so one more time, and I'll type it in here too while I'm saying it to you. Pete already did it for me. 806-677-5668. My email address is tdowell@tamu.edu. I'll type it as well, tdowell@tamu.edu. All right, I have 2 minutes. It looks like. Oh, and Mike and Kathy, thank you. My contact info is on one of the first slides. I'm going to run back to that really quick, Pete, and then I'll let you do the survey. Is that okay?
Yes, that'll be fine. As she's scrolling back, let me say this, that our next session, there it was.
There we go.
Let me just say,
Okay, so
our next session is going to be unintended consequences of grazing, and Dr. Wayne Succo will be speaking to us in August. Look for that, and now let Tiffany answer some questions. At the end of when she finishes asking the question, you'll have a survey pop up. Please answer the questions for us. The survey helps us improve.
all right, so I'll just try to go through a couple of these questions that I can see here. Andy asked if I have any good resources and information on the new EPA regulations and understanding the changes. Yes, I've been doing quite a bit of work on that. There is some information on my blog, but if you will email me, I've got a couple of charts that I think are particularly useful because they're kind of not biased one way or the other. They're pretty factual, which is kind of hard to find. But if you will contact me, I'm happy to get you that info, Andy. Steve, I see here, you're asking if I am a Texas water attorney. I am an attorney licensed in Texas. I'm employed by Texas A&M AgriLife Extension, so I don't represent private clients in the states. If you're in need of an attorney, I'll be more than happy to help refer you, and hopefully that'll be helpful. Aggie's asked for me to put the charts on my blog. I will be happy to email them to you, Aggie, but also I'm hoping to have a blog up kind of on an overview and the impacts of the new rule in the next couple of weeks. It's like, I think it's, I don't know, something like 500 pages, so it's taken me a while to try to get through that. There was a question here a minute ago about does the TCEQ have water cops? The TCEQ does have enforcement divisions throughout the state. And then, like I said, also folks can contact TCEQ and make priority calls, like was done with Dow Chemical. Pete, it looks like we're out of time. I want to make sure you have time to do your survey. Thank y'all so much for attending.
Let me say
today.
this session was recorded, and it will be linked to our website. And Tiffany, I can also send you a link if you'd like to link it from your blog, where they can listen to the session.
Yeah, that'd be great.
Well, y'all should get a pop-up on survey. Please answer the survey. If it covers up your screen, if you look down at the screen, you see a little icon with like 3 little men around the screen. You can get that back to the Adobe Connect. Tiffany, thank you. It was great. Enjoyed having you here today.
Yeah, thank you, Pete. I appreciate it.
Thank you all for coming, and look forward to y'all coming back. The next session will be in August.